What does a seller have to disclose when selling their home in Virginia? We'll cover that today on Frequently Asked Friday. What is going on, party people? In this video today, we're going to be talking about what a seller does and doesn't have to disclose in the state of Virginia when they are selling a home. Be sure to stay to the end because I'm going to give you the handful of things that you'd be surprised that a seller actually does not have to disclose. Before I jump into that, if you would, like, subscribe. If you like this content, smash that like button, hit that heart, give me a thumbs up. Do whatever. Give me some love on the algorithm. Thanks in advance. All right, so before I jump into this content, I do have to make the required disclosure. I am not an attorney, nor do I play one on TV. This is not legal advice. This is certainly just for entertainment and discussion purposes. So if you have any question, contact an attorney. They're going to be a lot smarter than me. They went to more school. They're more responsible. They floss their teeth. I don't, right? So just talk to them. But let's have some fun. All right, so in the state of Virginia, we have something called the Residential Property Disclosure Act, which is essentially says that there are 10 things that a home seller has to disclose if and when they're selling their property, but there's a lot of things that don't fall under those 10 headings that they do not have to disclose. Virginia is what's considered a caveat emptor or a buyer beware state. That's Latin. That's about the only Latin I know, which essentially says let the buyer be aware. In layman's terms, there's more of the responsibility on the buyer to discover an issue than it is the seller to disclose it, right? So there's only 10 things, as I mentioned, that a seller has to disclose. Let's jump right into it. All right, first and foremost is the first sale of a dwelling. So we actually don't need a disclosure statement on a new construction property. However, if a builder is aware of any defects or any issues that are not compliant with code, they are required to disclose those to a prospective buyer when they are selling a new construction product. So sorry to interrupt the video that you're watching, but if you would ever want a no hassle, no obligation market analysis to find out what your home is worth in today's market, or maybe you want to chat about the home selling process, or maybe even want to chat about the home buying process, feel free to call or text me at the number below, or you can email me at chris@elliottreteam.com. I'll let you get back to the video. Secondly is Planning District 15, and no, this is not Hunger Games. So I'm just gonna read it to you. If there is knowledge of previous mining operations or the existence of abandoned mines, shafts, or pits, you are required to disclose those. So if the 7 dwarves and Snow White come to your property every day to go to work, you gotta disclose that when you sell your real estate. Next is a military installation, and that means that properties in location in which there is a military air installation, that has to be disclosed. My understanding is none of Central Virginia, Metro Richmond falls in this category. Our friends at Virginia Beach have to worry about that, but most of us in Central Virginia don't. Next is building code or zoning ordinance violation. So if you have a pending violation, meaning you've gotten a love letter from your local county or city that you have a building code violation or a zoning ordinance violation, meaning you are operating outside of your prescribed zoning, those are issues that you have to disclose when you go to sell your real estate. My understanding, once again, not a legal opinion, if you know of those issues, but you don't have a pending violation, meaning you haven't gotten cited by the municipality, you're not required to disclose it. Your real estate licensee would, but you as the seller, as an unlicensed seller, do not have to disclose that. Next, this is always a fun one. If your property has been previously used for the production of methamphetamines, so if you've been cooking meth in your bathtubs, you are required to disclose that. Hate to break it to you for all my Breaking Bad fans. That's got to come out. Now, obviously, the folks cooking the meth and selling the property are usually not making their required disclosures. Where this does become applicable is if somebody's bought in a meth house and renovated it and want to resell it, that does have to be disclosed. So I'm just going to leave that one there. Next is if you have a privately owned stormwater facility. Think you have a detention basin or a retention pond, you have to disclose the long-term maintenance and or inspection requirements of that privately owned stormwater management facility. Next is a septic waiver. If you have a septic system that is currently subject to certain repair maintenance requirements from the Virginia Board of Health, and you've obtained that waiver from the Board of Health, then you are required to disclose that. That waiver does not carry over to the new owner. The new owner would have to go ahead and bring that septic system up to code, but that is something that you would have to disclose. Next is repetitive flood loss. So if you have flood claims of more than $1,000 from the National Flood Insurance Program within a rolling 10-year period since 1978. If your property gets a lot of water, you got to disclose that. Next is Liz Pendens. So this is if there is a pending lawsuit against the dwelling, such as an ownership dispute, foreclosure, a contractual debate or contractual dispute rather, or divorce issues related to the real estate. That is something you have to disclose. And then last but not least is the duty to disclose ownership interest. So if you are a real estate licensee and you're selling your own property, or you're representing a family member, or a business entity that you have an ownership interest in, you have to disclose that when you go to sell your real estate. So here's what's really interesting. Here's some of the things that you don't have to disclose in the state of Virginia. You do not need to disclose property condition. So unless you are a licensed, a real estate licensee, you can be fully aware of issues with your property and you are actually not required to disclose them. Secondly, property survey. So you don't have to have a property survey. You don't need to provide one to a prospective buyer. Third is a death in the property. Yes, I have some interesting stories that I won't go into in this video. But if somebody died in that property, on the property, in the front yard, in the basement, on the roof, that is not something you have to disclose when you go to sell your house. Fourth, always kind of an icky sticky one, is sexual offenders. So if there are registered sexual offenders that live in your neighborhood, hopefully they don't live in your house, you are not required to disclose those. So for my folks that are buying a home, it's always a good idea to check the sex offender list, registry, which is usually posted online, just to see who's moving in or who's already living in the neighborhood that you're buying into. Next is defective drywall, and then also, last but not least, lead pipes. Those are not things you have to disclose. So once again, in summary, Virginia is what's considered a buyer beware state. There's only 10 things that you have to disclose. Hopefully we did a good job explaining those in this video. If you have any questions as far as what you do or don't have to disclose, don't shoot me a DM or a comment below. Talk to an attorney. But if you have any other questions, shoot me a DM, throw me a comment, give me a like, give me a not like. Yeah. So thanks for tuning in. Look forward to seeing you next week.